Good morning, everybody. Welcome to August HR and Employment Coffee Break briefing. Slightly, maybe less formal one today. Sort of thinking August, summer holidays, school holidays. Might do something a little bit more relaxed and maybe nothing that was sort of too intense and too legal. That said, still a very important topic today. We are going to carry on sort of our themes from the Employment Tribunal series that we've been doing over the last few of these. And today's session we'll start to look at, I suppose, the epilogue, what happens after the Employment Tribunal, after all of the lawyers have gone and all of that's been resolved. So we will be carrying on from the mock tribunal case study. Again, you don't need to have known that in detail in order to engage today. We will talk about it as and when we feel we need to. It is much broader than that. But first, I've got to introduce my two co-presenters today. Many of you will know Nathan Andrews, our head of HR services, who's joining me today. He is here, frankly, because he'll have had more of these conversations in-house than I have over the course of his career. Some of you will have experienced conversations with me and my colleagues about tribunal outcomes. Some of you will not have done. But I'm fairly sure Nathan's done a few more than I have, one way or another.
Over the years,
I'm also joined by Justine Mears, who is currently a trainee solicitor in our team. She is due to qualify in September. She will be joining us. So those of you who are our clients, you will get much more used to dealing with Justine in the future. And we thought it would be a good baptism by fire, really, for her to start doing some of these with me. So today's session, outcomes of the Employment Tribunal. As I said, we ran through a few building up to the mock tribunal that the team and I hosted in June. We did the background to that kind of claims that the tribunal can deal with, tribunal process and procedure. We then had the mock tribunal event itself in June, subsequent session in July last month where I looked at the potential outcome for that case, which you'll recall was a successful constructive dismissal and sex discrimination / sexual harassment claim. The employer in that case, we sort of concluded then could have been looking at a claim value of somewhere in the region of 40, 50 odd £1,000, plus their legal costs, of course, making it quite an expensive series of mistakes that were made in that case. Purpose of today's session then is what happens next internally, and whether you have a successful or unsuccessful tribunal case, this is always an important process. How did we get there? What happened? What went wrong? Plus, as you'll see from the screen, and I'll touch on in a moment, a series of practical situations that are going to arise, really, and things that you're potentially going to need to address. So I will be handing, sort of as I hinted a moment ago, primarily over to Nathan for today, but we will be looking at the crisis management, the PR side of the negative tribunal case. What happens internally, the staff who were involved, whether that's HR, line managers. Don't forget, in a discrimination claim, the successful employee may still be there. I think that's something we could potentially touch on. The post-litigation review, so that's both the conversation that you may have with your legal representatives about what happened and what the outcome of the case actually means, and then what happens internally at board level and filtering down from there. And towards the end of the session, as we've indicated there, repairing broken relations, rebuilding the employer's reputation. I think the intention today is to make this reasonably interactive. I know we quite like to do that with these sessions anyway, so please do make use of the chat. Please do make use of the Q&A. We will interact with you. We'll answer questions as we go where they're appropriate. If anybody's got their own experiences or anything they want to contribute as well, please do. We're quite happy to talk about it. Nathan, as I say, I'm going to let you lead today. You've done these much more than I have, so over to you.
Thank you very much. It's nice to be with you all this morning, and obviously this is a really important topic to talk about. As Chris said, we will often talk about, and certainly in his work and the work that Justine does, we'll talk. They will talk to clients about potential claims and claims that are being made to the tribunal and representing and defending those claims. So they're often a focal point as you're going through the process. But often, what we don't talk about in any real detail is what happens once you've gone through that process. And that can often be a series of steps that organisations need to take to be able to understand what led to that tribunal claim, then what do they need to do afterwards to potentially repair working relationships, to understand how they arrived in that situation in the first place, and then what do they need to do to help mitigate any risk of being in a similar situation in the future. So the first stopping point really is to talk about, as Chris has said, bad press, crisis management, impact on staff morale, strained relationships. All of those things are real things that do impact teams and people that are involved in the process. And I think it's an important point that we touch on those things and set out some kind of practical steps that you can apply in practice within your organisations, particularly if you are facing defending a tribunal claim. So the first thing I always like to talk about is following a judgment being made in an employment tribunal, because often that, as I say, that is the focal point. You get the ET1, you then think about, the complaints or the allegations that are being made, you think about the defence, that's when you'll be instructing lawyers such as Chris and Justine, you're thinking about the ET3 and getting that off, and then going through the process of gathering evidence, witness statements, etc. So that's kind of the front end of the process, which we all tend to focus on. The one thing I often say, and I'll say this to anybody, be that a claimant, be that a respondent, going through a tribunal process, it's not for the faint-hearted, it's a grueling process. I think Justine and I can recall just from the mock tribunal experience, being witnesses, being cross-examined, that is a challenging process to go through, particularly under cross-examination. I've been in that situation professionally when I was back in-house in corporate roles, as a head of HR, where you're having to defend your position or defend a process that you followed. So that whole process is very grueling, especially for people who are not in roles such as HR or management roles. So where you maybe have colleagues who are witnesses, to incidents or events that took place. So I think, I emphasise this intentionally. The process is a tough and difficult process, and it can often give rise to tension in working relationships following that process. And that is often because when you go through a process of giving witness statements, gathering evidence, you can often have contradictory evidence. Cross-examination witnesses can often uncover conflicting statements. Sometimes people perform better than others going through that process, and so things can come out, when they're giving evidence that you weren't expecting or anticipating. Sometimes I've seen some practice where you might have one party who's made a statement when they were giving their evidence that another party feels that has, left them kind of with a negative viewpoint. It could be that they feel they've been criticised or thrown under the bus. These are comments that I've dealt with before and had to deal with post a tribunal process. That leads to this perception of damage to personal and professional relationships, and that's a real significant issue and something I certainly focused on in my career, following a tribunal process, because often you are left, in the wake of that, going through a tribunal hearing, you're left with some very difficult emotions from parties involved, and left unchecked, those things can escalate, and you can end up in situations where you have grievances or people saying, actually, I can't work with this person. That you've probably experienced that yourself over the years, Chris.
Yeah.
So it's something that is, you really need to be focused on. Company reputation, again, is a big issue, and depending on the size of your organisation, I've worked in big corporate entities where you feel more shielded. I've also worked in small organisations where going through an employment tribunal process, it can feel very personal, particularly if you have a small board of directors or senior management team and they feel that actually they themselves have been criticised. It can feel quite personal and like you're being attacked. And often, and I've heard Chris advise in this way, and I will certainly advise in this way, is that what you need to do is remove the emotion when you're dealing with these situations and try and focus on the facts and the process. But that's much easier said than done in reality, because when it is your business and if it's a small organisation, a number of people are going to feel the impact of a pending tribunal hearing, and certainly you're going to feel the impact coming out the other side. Reputation as an employer, again, these are very real issues, particularly if you're working in a sector where recruitment is more challenging than maybe other sectors. If you're going through a tribunal process that potentially becomes public knowledge, that can make things very difficult. And so, from my perspective as an in-house head of HR, when I was holding those types of roles, that was a real concern for me as an HR practitioner. How do we mitigate the potential risk of damage to our standing as an employer within the local business community? So again, these are things that you should give consideration to. When we talk about bad press, some of the things that I certainly would focus on internally, and something certainly I would be talking to clients about, is that we should have a focus on negative publicity. So how does a potential claim potentially impact our brand image? And this is something that you want to get in front of. I certainly wouldn't wait for you to get through the other side of a tribunal hearing. I'd think about these things now and kind of formulating a strategy around. We need to work with our lawyers to get through the process, but we also need to be thinking about particularly depending on the nature of the claim, what damage limitation do we need to do and who do we need to work with in terms of managing that. So certainly from my own experience, internally, I'd be looking at, working with a PR specialist who can help us with that kind of PR common strategy around how we manage, going through the process and coming out the other side. I certainly would be talking about the potential damage to our reputation as a business, and I'd be having those conversations with my senior management colleagues, so it'd be with members of the board, managing director, people in key decision-making roles who need to come together and work together to make decisions about what they do to mitigate risk to damage to reputation. I purposely put in the slides, and I think these are good takeaway points. When I talk about damage to reputation, some things I would think about is how that could suggest to the general public, to potential new hires, that we might have poor HR practices, weak leadership or management issues, or there might be cultural challenges. These are things that are, for me, from my perspective as a senior leader within a business, I would be worried about, because I don't want people thinking poorly of us as an employer. And as I've touched on this already, that can impact, I've seen it in practice, how it can impact and make recruitment much more challenging. And I think it's something we need to get in front of. We need to be proactive rather than reactive in those situations. We've already touched on recruitment and retention, but client and customer impact, again, client and customers may be less inclined to work with you as an organisation if they perceive that there are poor employment practices. So these are things, again, are very real issues that you need to get on the table, have some really upfront, open conversations, recognise limitations and skills within your senior team. If you're having those conversations, there's nothing wrong with bringing in external support. PR and comm specialists are really important. I think when you're going through particularly complex claims where you think there is the potential that it could get into the local press or even the national press, and we've seen that, haven't we?
We have, yeah, and I think there's a couple of important considerations there. I think one of the things you said quite early on this slide was actually doing this quite early. And I think it's important to remember that maybe 10 years ago, this was less of an issue. Employment tribunal judgments now are online, they're published, they are detailed things. Anybody on the call who hasn't seen an employment tribunal judgment, go on the website, have a proper read of one. There's loads that will just say, this claim has been dismissed on withdrawal. That usually means they've settled. A lot of the others, you'll find they can be 20, 25, 30 pages long, and they can be incredibly scathing. I mean, drawing on the mock tribunal is a good example here. We know the judge there was particularly scathing of the HR approach, as Mr. Ned here well knows. But that would all appear in the judgment. And that is all public record, and it is very, very hard to get that anonymised or redacted. There's a principle of transparency of justice. And I think what's important to take as a step backwards from that is, in principle, with the employment tribunal, so is the entire process. Anybody can turn up to an open hearing. The press do occasionally get interested in cases and do turn up at them quite early steps. People will be familiar with the cases that we've followed anyway. You think the holiday pay cases, the equal pay cases, the worker employment rights status cases, they were all being followed long before final judgment. And we were all commenting on, and we were all talking about Next and supermarkets and Uber and all of these from a very, very early stage. And all of these things were relevant. There was a huge amount of negative publicity because people were aware, for example, that Uber were clearly proactively trying to not give worker rights to people. And that's true in these cases as well. And again, we think back to the mock tribunal, and again, some of the points you're making on the previous slides. Contradictory evidence. This is always going to, I mean, Justine, you experience that even as the claimant. That's clearly what council was trying to get you to draw out.
Yeah, no, definitely. It's something that's council definitely were trying to get something to come out of me that's going to contradict what I said previously, or, get in line with something that Ned had said. And I think
Good old Ned.
I think definitely being put in that position is something that I can definitely now relate to, that I didn't quite appreciate how easy it is for people to put lines down for them to trip over. Definitely.
And if it happens to a claimant, it will happen to a respondent. So people do trip up. That's council's job. At the end of the day, is to find that contradiction and highlight it. Sorry, Nathan, back to you.
A really good point you made, I was just going to touch on, which is around contradictory evidence, because I've been, I've gone off to the employment tribunal several times over the years where, things haven't worked out the way we'd hoped, and you've we're having to deal with the claim. And no matter how much you prep and you gather your witness statements, and we think actually no, we're good, we know what's going to be said and what's going to be discussed. When somebody is on, essentially the witness stand in the tribunal, and they are being cross-examined, when you're dealing with that in reality, you can see people who are going, no, I'm fine, I'm really confident, kind of, I don't want to say crumble or fall apart, but you can see the nerves get the better of them, and suddenly things are said that you weren't expecting or anticipating that throw you a curveball. And then what happens is you might have, two witnesses who suddenly go, actually, I feel that person's now throwing me under the bus. I'm now going to have to be challenged on my own witness testimony. And you can see that, relationships start to be frayed even at that point. And, for me, I've been in situations where you have to start to manage it before you've almost even left the tribunal. Because you can see that people are becoming upset, and it gives rise to an emotional response because people feel it's personal.
And of course, there's that uniqueness in the employment tribunal in that the witnesses are usually in the room hearing what's being said. That doesn't happen in any other jurisdictions. No. You don't go to the criminal court and all the witnesses are sat at the back of the room. It's quite unique to the employment tribunal. It does happen, and people do hear these awful things that are being said either about each other, true or not. And as you said, this perception that a witness has said something that then throws you under the bus, and that may not even be the claimant. It may be two or three witnesses for the respondents who are all, to all intents and purposes, blaming each other in open court.
Makes for a very interesting experience. Again, this is going to feel a bit repetitive, but I'm going to emphasise this purposefully. It can be gruelling. Chris will know this, Justine will know this, I know this from experience being an HR practitioner. Going through a process, of preparing and defending a claim can be a really challenging experience. From the moment, as an HR practitioner or a business owner where you receive an ET1, that's the whole chain of events from instructing a solicitor, speaking to that solicitor, going through the initial, this is how we've arrived at this, receiving an ET1, gathering evidence and information that you want to send off to a solicitor. Now, if you've got an HR team, hopefully you'll be in a position where they would have gathered information. It's readily available. It's usually well organised, so you can send it off quite quickly. But I've dealt with cases as an external consultant where that's not the case, and then we support having to gather that information. That in itself can be quite laborious. It can be quite challenging because you might have to speak to people, you might have to gather, interviewing people, witness statements, copies of emails, policies, letters. There'll be a number of documents that you need to gather to then pass to your legal team, who are then going to prepare your defence and potentially prepare your ET3. So that process itself can feel quite long and drawn out and protracted. But the overall process can feel very protracted for all parties who are particularly involved, right from gathering evidence, speaking to your lawyers, going through the process of, preparing witness statements, etc., and then actually getting to the point where you go off to the employment tribunal and, you are going to give evidence if you've been identified as a witness. And so that whole process for people who are not used to dealing with litigation in that way, and often you'll find that is the case, and if you're dealing with employees, they're not used to dealing with these types of processes, as Chris is, who's in and out of the tribunal all the time. Myself as an HR practitioner, we're used to dealing with those types of formal processes. So one of the things I would always say is, at the front end, when you know that you're dealing with a claim, and some claims are more complex than others, so if you're, I think any claim is stressful, but if you've got a particularly complex claim where you might be challenged on process or procedure, as an example, it is good practice to touch base with the people who are potentially going to be involved, and make sure that you have support mechanisms in place. We manage expectations that, yes, we are going to go through a long drawn out process. Waiting for a date for a hearing, that can take a huge amount of time. So again, that can present its own challenges, just particularly if you've got people who are feeling quite anxious about potentially having to go and, say, be a witness, for example. They might have a long period of time to wait before they get the opportunity to go give their evidence and hopefully move on from that process. So litigation fatigue is something that is a very real thing in practice. I think, Chris, you've probably seen this in abundance in your career. I've certainly seen it on the other side, being an HR practitioner supporting employees and colleagues. And I think it's something we absolutely should be aware of. So I've put some information on litigation fatigue, and it's the feeling of being worn down by a legal process. It is a stressful process to go through. And again, I just emphasise that it can bring up a lot of emotional responses from people. So when you go through the process of trying to manage, your response to a claim, you can see people maybe not being at their best. they might respond negatively, and it's actually having an awareness that that's probably because they're feeling under a lot of pressure and stress. I certainly see that in line managers who have been, identified as a potential problem in a claim, and they feel that actually they're under attack and their position's under threat. And so, you're having to work through all of that as an HR practitioner to make sure that you can still work with your legal team, get the relevant information over to that team so they can start working on supporting you in managing that whole process. It can be very normal for one party to blame another, and as I said, for working relationships to become strained. And it's really important to recognise that early on and to make sure that you are building as part of your strategy. And I talk about this a lot. If you're facing an employment tribunal claim, it's really good practice at the front end to formulate a strategy, to think about all of the points that we're talking about today. What's our common strategy going to be? How are we going to mitigate damage to reputation? How are we going to work with people who are, subject to the complaints or the claim that's being made? These are things that you want to identify early on, so that you can think about, what do I need to do to support the people involved, to look after myself as I'm going through the process. I think that's really important, to make sure that you yourself don't get worn down or overly fatigued as you work through that process or working with your legal team. See, these are things that absolutely should be on your radar to work through with your senior management colleagues.
So we sat through the judgment. We probably sat through 2 hours of the judge telling us everything we've done wrong. We could see it coming from the moment the judge sat down. The instinctive response, whether that's immediately outside the tribunal room or 2 or 3 days later in a board meeting, particularly maybe for an in-house HR.
Yes.
How the hell did you let this happen?
Yes.
You must have been there. I've certainly been there as a lawyer. Why did we lose? How did you let us lose? And that's one of those other ones that needs to be addressed very quickly, very much on the head, but in a certain way sometimes.
Yeah, I think certainly from my experience, and certainly the more experience I became in my career, I handle those conversations very differently. And what I did learn early on is actually, as a senior management team, we all have a role to play in taking responsibility for things that occur within our organisation. Certainly, as when I was in the house head of HR, I would always say, look, I play a contributing role in how we develop the culture of the organisation. Certainly, as the lead HR practitioner, yeah, absolutely, I have a handle on policy development, making sure line managers are equipped to be able to manage their teams. But sometimes it is also about having those difficult conversations. And I've dealt with situations where I've advised, given good advice, that advice wasn't followed, and then we've had to deal with the claim thereafter. And one of the things I learned really quickly is when we're having those conversations, and again, people are angry, they're feeling bruised, they feel that, if particularly in a situation where the judgment was in favour of the claimant, is that people feel that, HR's let us down. And it's about working through that process, having those open, honest conversations, defending your position where necessary, but also not being overly defensive, because that can get in the way of having those open, frank conversations that will help parties move forward. So for me, absolutely, I'll take my share of responsibility where necessary and where appropriate. But I will also have upfront, honest conversations with people about where I feel things may have gone wrong and what we could do in the future to prevent that from happening again. So I'm very much happy to, reflect, look back and go, okay, let's look at what happened. But let's also get very quickly forward focusing, so we can identify what can we do to, improve our processes, look at our policies, etc., to make sure that we don't face a similar situation in the future. It's all about communication. It's all about working together as a team. I'm talking, if you're a member of the senior management team, it's about building, relationships with your colleagues early on, and making sure that you adopt a united front. I think that's really essential.
Yeah, and I suppose this should be a lot easier if, going back to what you said before, that correspondence with us or the appropriate legal rep, as the case may be, has happened openly and frankly all the way through as well. I'm hoping people on the call who are our clients will confirm this, but part of that conversation that we certainly would always have with them before representing is, these are your risk areas.
Yep.
This is where something may go wrong. We can't guarantee that a judge isn't going to turn around and say that conversation's a real sticking point.
Yep.
And we lose on that point. And it's not a case necessarily of assigning blame at that point. That conversation has happened.
Yeah.
Now, okay, it may have been an open and deliberate act of discrimination. Fine, we will handle that.
Yeah.
But 90% of the time it isn't. We've said on these sessions before that miscommunication, misunderstanding, poor communication between the line manager and an employee tends to build towards a lot of claims. And yes, assigning blame is natural at this point, but I would suggest mostly unhelpful.
Yes, and I think there's a big role for HR to play in that, in terms of managing those relationships. And sometimes it does feel like if you're on the call today, and you're in an in-house HR management role, I'm sure, and you've experienced kind of situations like this, it can feel like you're going to go with a tin hat, and you have to referee and kind of mediate between parties to keep the lines of communication open, and that's really essential. It's not an easy role to have, but it is the role that we have to play as HR practitioners. But if we don't do that and we allow lines of communication to break down particularly between senior management colleagues, that can have a really detrimental impact on how you respond to the process, how you interact with your legal team, how you gather information to help defend a claim. So it's really important that early doors we are upfront around this is going to feel difficult, it's going to feel uncomfortable, it's going to mean that sometimes we're going to feel defensive and we're going to build a brick wall because we feel that we're being criticised or attacked. It's about owning that, acknowledging it, and then saying, look, we're all here to support one another. Often when I talk about, when I've worked with client organisations, who are expecting or anticipating receiving a claim, some of the things I talk about early on is like let's identify who potentially is going to be impacted, who's going to be involved, who's going to be called on as a witness, and let's look at what can we do in practice to support those people. And it might be that you have an EAP package in place where you can say signpost your employees to contact their EAP if they need additional support. I've worked with organisations before that have brought in counselling and coaching support for parties in advance of that process, just to get people in the right mindset for dealing with what's likely to follow. And again, as HR practitioners, working with those people who maybe are not used to this type of process, working with them to help them understand what is going to happen. I've been in in-house roles where I brought in our employment solicitors early on and said, right, let's have a session around what does the process look like, what does the tribunal hearing look like, let's get it out in the open, let's manage expectations to help reassure people. Because I think once they have an awareness of what it looks like, they can start to relax into, okay, I know that giving evidence is going to be uncomfortable, but I know what that looks like in terms of the process and the layout on the day. It's a bit like our mock tribunal.
Yeah, exactly. And I do find that helpful, especially if you're going to have 5, 6, 7 respondent witnesses, all who have worked fairly closely together on things anyway, perhaps within the same team, the same departments. Yeah, that can be a useful exercise. And I think one of the best witness coaching sessions I ever saw, and of course as lawyers we're not allowed to coach, we can't tell witnesses what to say, we can give an idea as to what cross-examination points might come up, and obviously we will have advised on areas of weakness. What we can't do is kind of guide what that evidence is going to look like, but what we can do is help prepare for the experience. And one of the best examples I may have told you this story before, and I can't even remember if I mentioned it on a coffee break briefing. The Employment Lawyers Association put on periodic regional and national conferences, and one of them down for our region had called in one of these witness coaching agencies and wants to kind of guide people and teach them what being a witness is going to be like. And they used one of the host firm's lawyers as this mock witness and strapped them up to a heart rate monitor. Right. And it was really, it wasn't then on a case. They started quizzing them on their music knowledge. Right. And they were using a real barrister to cross-examine, and she was very good, very, very strict approach to cross-examination. And you could see the questions building towards, what's your favourite song? You know that song really well. Would you say you listen to it a lot? Yeah. And we could watch this heart rate spiking. And it was really quite fascinating. And you could see this actually quite experienced litigator, not in a situation where there was any real stress as such. There wasn't anything determinative in this exercise. But they had worked out very quickly that this cross-examination was building towards, so you could sing a line for us. Or you could sing the chorus. I think it was about ABBA. You could sing the chorus of Waterloo, could you? And this heart rate, it doubled from resting rate, just being cross-examined on something they knew inside out anyway. And that fear and that stress and that pressure. You then take that back to the workplace. Yeah. You put me in this situation. Yep. It's then how this employee is feeling. I think it's important to remember that.
Yeah, I think that's a really good point, actually. And over the years, dealing with this, I've been doing this work for 20 years, and unfortunately, we have dealt with tribunal claims, sometimes things just happen, no matter how hard we try to make sure we follow a fair process and that we do all the right things in terms of making sure our line managers have relevant training. So when things do go wrong, the nature of dealing with people, we're complex beings. So things come, working relationships can sometimes become strained and frayed, and we end up in a situation where, like we're talking about today. I've certainly experienced people coming back into the workplace feeling quite angry and aggrieved that they feel that, I've been let down. I've dealt with line managers who've come back and said, actually, I don't feel I was supported. I don't feel I was given the right training. I don't feel that, HR was there enough to support me in terms of managing the relationships I have with my team. And so that in itself can give rise to conflict. It can feel, from an HR perspective, particularly if you're in a standalone role, and I've been there, I've been in a standalone, several standalone HR manager roles. That's a lonely place to be. If you're the sole HR practitioner within an organisation, you also sit on the senior management team. The buck stops with you. There's no one above you. You've got no one below you to be able to share, the load with. And so that can feel like a very bruising experience. From your perspective as an HR practitioner in-house, because you're having to not only manage the process, deal with the lawyers, deal with your senior management colleagues, you're potentially having to then deal with the fallout from people who are in more junior roles who feel that actually, I'm feeling aggrieved that I've had to go through this process. It's had an enormous effect on my mental health. It's caused me to have stress and anxiety. And so you then have to work through that kind of process as well. And so I think it's a really important point to have an awareness of that. These are things that might come up that you might need to deal with. And I can't stress that enough, certainly from my own experiences of being in-house roles.
So we were talking a short while ago about kind of that immediate legal review that you would get from us. We'll obviously explain what's happened with the judgment insofar as we need to. Hopefully, a huge amount of it won't be a massive shock. If the judgment does go against you, there should have been some kind of indication from us that the risk was there. That legal review is going to go, this is why we lost. This is the thing that happened that was the nail in the coffin for us. And okay, that's a reasonably objective exercise. Yes, of course, there's going to be emotion involved, but at the end of the day, that is a lawyer explaining a legal judgment to somebody. What then happens and how you translate that in-house into what needs changing, what needs to happen next, what do we maybe need to review, that is a very different exercise.
Yeah.
But equally, in both cases, it's one that's going to happen either way. Even if we win, even if we successfully defend a claim, that conversation still needs to happen because something has led to the point where we're ended up in final hearing for whatever reason. Yeah. So parking the kind of immediate legal review that we would do and maybe talking about that post-litigation stage internally.
Yeah, I think another great point you made there, Chris, actually is this, and I've seen this, we've go through a process where you've received a claim, you go through the whole process, get into a hearing, defending that claim, and actually, the judgment's in favour of the respondent, the employer. Often people go, actually, it's amazing, we've defended that claim, awesome. One of the things I would always say, and I've certainly dealt with this in practice in my career, is even if we have been successful in defending a claim, that's not something to celebrate, because what I want to know as an HR practitioner is, how did we get there in the first place? What led to that claim being made and going to a final hearing, and us having to instruct lawyers and going through that whole process, which, as we've already established, can be long, it can be drawn out and protracted, and it can feel difficult and enormously stressful. So whether you have successfully defended a claim or not, as the case may be, for me, the most important outcome is the post-litigation review and being really intentional about how you conduct that review and being systematic in terms of looking at all the key stages, right from what led to the claim, what you did thereafter, so that you can identify lessons learned, understand what happened, how it happened, and what will you do differently as an organisation and as a senior management team moving forward, so that you don't have to be in that situation again. So for me, this is something I would do early doors. So I'm a big fan of Chris and Justine will know this. I love Excel. So I will, I start gathering information right from the moment I think we potentially could receive a claim, to understand what have we done, how did we respond to, say, if it was a grievance, how did we respond to that grievance, what did we do, what action steps did we take. So I collate that information so I go through the process, because what I want to do is when I get to this stage where we're going to have a post-litigation review, and I often will involve our employment lawyers. So with this, when I was in-house, I would get in our employment lawyer and say, look, I want to go through this, I want to run a half-day session I've dealt with complex matters where we said we'll allow a one-day session where the senior management team go off site and we really dig deep and we really do some self-reflection and we have some open, honest conversations around lessons learned. And from that process, from that kind of reflection process and working with the, our employment lawyers, we were able to identify, do we need to review our policies and procedures? Do we need to amend those policies and procedures to make sure that they are fit for purpose next time? Don't get me wrong, I'm not suggesting that we go away and rewrite policies for the sake of it, but I would absolutely recommend we do it when there's a genuine need, where we've identified that those policies stop short of making sure that we dealt with things in the right way to keep the organisation safe. And ultimately, that's what we want to do. We want to protect our organisations, protect our people, make sure that we are looking after our brand image and our reputation as an employer within the local business community. These are all important things. So absolutely look at your policies if that's needed. It might be that you also look at ways of working and standard operating procedures. It might be that you identify things that need to change in order to protect the organisation moving forward. So if you do need to establish new ways of working, again, these are things that you might need to talk to your employees about. You might need to consult with individuals over any proposed changes, but they're things that you need to be thinking about and certainly identifying at the end of a tribunal process. And finally, training can often be a key aspect as an outcome of a tribunal process. It might be that we identify that we need to retrain our line managers and supervisors, for example. So anyone with line management responsibility for people, it might be that we need to put them through refresher training, new leadership or management training to give them the skills that they need to be able to manage in the right way to mitigate the risk of future claims being brought against the organisation. So the post-litigation review for me, as certainly when I was an in-house practitioner, and even now if I'm working with a client organisation, I would say this is really key if you want to make changes to prevent claims being made against you in the future. I think, and you would probably agree with that.
Yeah, absolutely. And I mean, the policy document review is an interesting one as well. And Justine, classic trainee job, review this contract, review these policies for us. We won't name names to embarrass any of you lot, but even in doing that, even where there's no litigation in the background, you ought to see things where there's a red
flag. Yeah, exactly. We'll often look through like policies and things that we can then pick up that maybe things haven't been updated when new legislation or new things have come in. So yeah, that's something that we definitely
and it kind of stresses the importance of doing that routinely, and as you said, not amending or redrafting policies for the sake of it, but just think we've had an 18-month process that cost us 60 grand. If somebody had checked that policy 18 months earlier, then it may not have been picked up.
It's a really interesting point actually with policies, and certainly, I mean, it's less of an issue for me today in the role that I hold now. But when I was in-house, and I had a team, we had an annual project plan, and so we would plan in our annual cycle of reviewing our policies. We would do a lot of that work ourselves as an ER team, but we would then, depending on the policy, we would send it out to our employment lawyers, get them to review that, to say that these are the changes we've made. So we went through an annual process every year of just reviewing the handbook, the policies and the procedures, and our standard operating procedures to make sure that those documents weren't just kind of created and put in the top drawer of your desk and left there until there was an issue. So for me, it's really important when we have policies and procedures and standard operating procedures, they should be living, breathing documents. They should be documents they're working documents. We should be reviewing them on a regular basis. We certainly should be making sure that we're reviewing them when we know employment law changes are coming about. Very easy to overlook it because, we are exceptionally busy and, the day job can get in the way. But actually, I've lost count over the years of how many times an employment lawyer will say to me, have you got X policy? Yes, we have. When did you last review it? Oh, 2-3 years ago. So if you can plan in an annual cycle of when you're going to review your policies and just going through that, or indeed if that's not something you have time to do, then consider outsourcing it. But make sure that you certainly do an annual review would be my viewpoint.
Right, we've talked about all the damage.
Yes.
We've talked about what can happen. We've talked about how unpleasant that can be, both in the tribunal itself and then for weeks, months subsequently. Let's talk about fixing some of this.
Yes.
Relationships.
Yeah, I mean, relationships are for me, certainly from my experiences, relationships are the biggest thing that are an issue post an employment tribunal hearing. because as we've already established, people can feel quite attacked. Sometimes you can have situations where you've got contradictory evidence, where somebody will, one party will say, I felt I was thrown under the bus by this person, I feel that my reputation and standing within the organisation has been damaged. These are all things that we need to be aware of and to take proactive steps to address. There are some steps that you can take to help alleviate tensions and repair working relationships. Facilitated conversations post-litigation can be enormously helpful. So for those of you who are not aware of what a facilitated conversation is, it's almost like a short form mediation. It's where you have two parties who don't necessarily have a full dispute with one another, but there are challenges, and it's a good mechanism, early stages, to get people together and to table any issues and to work through that process with them. So a facilitated conversation would look like someone like myself as a trained mediator having a conversation where I would facilitate between the two parties, but allow them to talk and to communicate with one another in order to help the other party understand their perspective. So I think if you can be proactive in offering those kind of support mechanisms like a facilitated conversation, that can be enormously helpful. Now, sometimes, and I've seen this in practice, where you come out of this tribunal process and mediation is required because you've got two parties who are in conflict with one another, and it's normally over evidence that's been given, where somebody says, actually, I disagreed with what you said, I didn't feel that was a fair representation of what happened, and I feel that I've lost trust in you. And I've often offered mediation. So when I was in-house, I brought in external mediators because that added a layer of independence and impartiality. But as long as both parties were prepared to go through the mediation process, the outcome and the success rate of people reaching an agreement and being able to move forward is actually really high. So again, early stages when you're thinking about, am I going to receive a tribunal claim from this employee, these are things that I would be thinking about and looking at costs and budgeting that in, along with my costs around legal expenses and so on, because it's good to be at the front end, to be aware that you might have to bring in external parties to support you in helping people move forward. So mediation is something, I'm a trained mediator, I'm a big fan of mediation. I think if all parties in dispute are in agreement, let's get them through that process, because actually if you can help people reach an agreement to move forward in a meaningful and positive way, that's going to have a benefit to the organisation. I'm a big fan of informal debrief meetings following a tribunal process. I think that can be really helpful for all parties involved to just have a debrief, to talk about what's happened, to do that reflection piece, to check in with one another, asking parties, how are you feeling? Is there any support? Is there anything I can do to help you so that you can move forward? I've seen it in practice where you have line managers or supervisors who have been subject to a complaint that's gone to the tribunal. Often they will, have lost confidence in their approach to managing people. They might have lost confidence or have anxiety around having difficult conversations with people, which are all part of being a line manager, and they have to be able to do that in order to be effective in their role. So again, it's identifying, are there any issues? What can I do to help you? And when you identify what support people need, it's acting on that proactively and quickly so that you can help people move forward. Coaching and team development opportunities, again, can be enormously helpful, particularly if you're supporting people in line management roles who've got responsibility for supporting and supervising people. That can be really helpful in rebuilding confidence. It might be that, as an output from your post-litigation review, you might have identified that a particular line manager or a group of line managers or supervisors may have fallen short in their management responsibility, and we might need to retrain them and also help facilitate changes in patterns of behaviour. And that's where coaching can come in. So again, that could be a really useful mechanism for you supporting people who remain in the organisation to move forward. Now, I've not put this on the slide, but I've also dealt with situations where, following a tribunal process, we've ended up reaching agreements with people to help them move on from the organisation because they felt that actually they were unable to stay, and actually on reflection we felt that it might be in their interest and our interest that we reach an agreement on a party of the ways on agreed terms to help the organisation and the individual move forward. So again, that can be an output. I've seen that, and how we manage that and doing it in the right way is really important to avoid any other claims. And that's where get your lawyers involved, have conversations about what you want to achieve as an organisation. But identifying these mechanisms and factoring in the costs involved early on, building that into your strategy will be enormously helpful, because whether we like it or not, when you know you've got a claim, and if you think it's likely you're going to go to a final hearing, you're going to have to go through that process. So we might as well be organised, planned and intentional in terms of how we manage that.
No, absolutely. And then taking us full circle, I suppose, first thing we really talked about was the publicity, the reputational damage that comes with an employment tribunal claim. And again, for those of you who attended it, or those of you who were on last month's session when I talked about the facts in a bit more detail, the mock tribunal is a great example of this potential reputational damage, both to individuals and the business. Let's not forget the judgment was ultimately one of sex harassment and sexual harassment, but the fact pattern, I mean, for the claimant, we're talking about some very personal experiences. For individuals concerned, we were talking about disclosing an affair, that an individual was a sexual harasser. There's a huge amount of damage here been done potentially to both individuals and the organisation more broadly. Scathing judgment for the organisation itself. And that is often the case. There is regularly quite a serious criticism of the organisation collectively. And some of the best examples I can give on this, not wanting to dwell on the policy point too much, is employers who try to run that all reasonable steps defence, a discrimination claim. Where that fails, a judge will be incredibly critical if there's been a failure in performance processes, in training, in implementing policy. And there's some really nasty judgments out there. Your policy was archaic and nobody bothered to read it, could be a quote from one of these judgments. And that does cause human reputational damage. The fact a claim exists in the first place does reputational damage. And those of you who've been on the receiving end of this will know it's a classic line in that pre-action letter, whether that's open or without prejudice. Consider the reputational damage to your organisation. That is part of what you're paying for here, by my client, i.e. the claimant, promising not to take this into the public forum. But that damage has happened. We must fix it.
And this is where you're going to have to bring to bear all of your commercial skills in weighing up how you handle and respond to potential claims, because as Chris has said, it will do damage to your reputation as an employer. I can't stress enough, I've been in organisations where I've really felt that firsthand. I've seen how, claims have made it much more difficult for the organisation to recruit top talent. You can see the comments that are made on social media. I mean, social media is such a prominent aspect of our day-to-day lives now, and I think it makes it much easier for people to make comment on your organisation and on individuals in those organisations.
And actually, I did notice recently there are a couple of both private and media organisations who are increasingly getting consent to live tweet tribunal hearings. I know there was definitely one who was doing one of the recent sexual harassment cases.
That's interesting.
Yes.
I mean, I think it's an interesting time to live in, really, because we will have experienced kind of the era where you didn't have social media, or certainly not the prominence of social media we have today, and now working in an era when social media is at everyone's fingertips. It makes it much easier in real time for people to make comment, and to also be kind of a faceless voice, kind of attacking your organisation and its reputation. So I can't stress enough that absolutely, when you're dealing with claims, you do need to bring to bear a commercial approach in terms of we need to respond to this claim, but can we reach an agreement to settle matters with a party? Is that going to be in our interests from a reputational perspective? These are things that you need to be thinking about. These are certainly things that we should be talking about with our lawyers, with any other specialists that we're bringing in externally, like PR, kind of reputational management specialists. We need to be having those conversations early on, particularly if you're dealing with a claim that you perceive as a significant risk of being particularly damaging. So for me, again, I talk about being strategic. What I mean by, I think, strategy and being strategic in terms that are so overused, but for me, it's understanding, being strategic in our approach, is understanding where we are, where we need to be, and then identify the steps we're going to take to get there. So I think absolutely formulate your strategy to rebuild your employer brand. Do that early door, start thinking about that as early as possible. Lean on people internally, but when you have a skill shortage, look for external support, because you want to get this right. I think some of the steps that I've outlined are based on my own experiences, but when you are looking at formulating your strategy around preparing your employer brand and mitigating any damage to that brand, you want to take responsibility, you want to demonstrate a commitment to resolving any underlying issues. So this is an opportunity to, be really honest. It's like holding up a mirror and really being honest with yourselves as a senior management team. Certainly, if you're in an HR team, being really honest with yourselves as an HR team about what went wrong, but actually, did we drop the ball on this? Could we do this differently next time? If we can, what do we need to change? So be open and honest. That could be a real, a brutal experience, but one that will help you formulate a really good comm strategy for you to take forward. I think when you're talking about, communicating and how you're going to formulate that common strategy, identify your stakeholders. So who do I need to communicate with, and be really clear on your communication. I think, if you want to demonstrate as an organisation that you are going to take responsibility and make a commitment to addressing any underlying issues, you want to be open and honest, and you want to be clear in how you communicate with people. I think that's really important. I've had personal experience of this. Be transparent with your communication. That is key. If people feel that you are hiding things or you're trying to water down things, that can often, make you appear disingenuous. It can make people perceive that you actually aren't committed to making change, so this doesn't happen again. So I think it's really important that you have a transparent comm strategy in place. If you are unclear on how to build that, seek professional support and advice, because if you get this right, it will go a long way in helping you mitigate as much damage to your employer brand as possible. When I talk about being transparent with your comms, you'll see on the slides, we talk about being open with employees, clients and other stakeholders, and it's being clear about the steps you're going to take to make sure things don't happen again in the future. That's really important. Ultimately is the aim. If you go through a process of defending a claim, you want to make sure that you're not there again in the future. Again, I've talked about this, but I will stress it again, getting external support. I'm an HR practitioner, I'm not a PR specialist. I don't, I'm not a fan of trying to wear too many hats. I would, stick at what I do best at, which is HR. And I've worked with PR specialists before in previous roles when I was in-house. They add enormous value when you're going through a particular process that can feel difficult. And actually it's really reassuring when you've got, a specialist expertise who can give that advice and input. It's a bit like working with people like Chris and Justine from an employment law perspective. Lean in on other people's expertise to help you through a difficult process. Again, we've talked about reviewing and updating your policies where necessary. Don't do it for the sake of doing it, but where it's appropriate, absolutely do that and do a good job of reviewing those policies. If you feel that you need a fresh pair of eyes, work with external parties who can partner with you and give you their viewpoint and their expertise. And again, consider what training may be required and whether you can do that in-house. If you've got an HR team, can you design and deliver the training that's required in-house? If not, look at ways of providing that from external sources. I think that's really important.
Okay, and I think we've done incredibly well on time there looking at that. Anything else from either of you on anything we've discussed today?
No, I think that my final piece, I think, would be if you are looking at potentially facing receiving a claim and defending that claim, is just being prepared early on, do the work early on to get your ducks in a row. It makes going through the process easier. It doesn't make it less stressful, doesn't make it less grueling, but it makes it less, it makes it easier for you to work through that process because you know what you've got to do and when you've got to do it by.
Yep, excellent. Justine?
No, nothing else definitely.
Same old. Brilliant. So what we'll do then, I can't see any questions, but if anybody has got any, I'll be talking for about another 30 seconds to a minute or so feel free to pop them in. What we'll do very quickly, let's just talk about upcoming events. So these coffee break briefings, as you know, start of every month. We've got the provisional dates there for you for the next 4. I haven't got any specific topics planned for any of those yet, so if anybody does have any suggestions, whether that's on the employment or the HR side, if it is something that you want us to talk about that's maybe a little bit more HR or employment relations focused, please let me know. Nathan and I and Justine increasingly now do all enjoy doing these together, so feel free. We can talk about almost anything within that remit somewhere between us, as you've probably noticed. So there's the next 4 dates for those. Our next in-person event, 24th of September, Captain's Club down here. That is likely at the moment, and that is plans to be an update on the Employment Rights Bill and where we're going with that, including the roadmap to implementation. Other than that, there's all of our contact details. Those of you who don't already, feel free to reach out, connect with anybody, LinkedIn, email, anything you want to talk about, you know where we are. Other than that, if people do want to head off, that's us done. Just want to thank Nathan and Justine for their time this morning. Thank you for joining me. Everybody else, thank you. Do hope you have a good rest of your day, good rest of the month, and we will see you as and when. Thank you very much, everyone.